Hello everyone, I'm Aratrika Bhaumik and I welcome you all to another episode of Quotes This Week on LiveLaw, where we update you about all the important legal developments that took place last week. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like this episode and if you like our content, please do not forget to like and subscribe to our YouTube channel. The Supreme Court of India has opined that all persons who have completed 10 years of sentence and whose appeals will not be heard in the near future should be enlarged on bail unless there are other reasons to deny them bail. A division bench of Justices Sanjay Kishan Kaul and Abhay S. Oka was considering a batch of petitions of life convicts in jail whose appeals are pending before various high courts. The bench observed, and I quote, "We can appreciate if any of the parties is delaying the bail itself, but short of that we are of the view that all persons who have completed 10 years of sentence and appeal is not in near proximity of hearing with no extenuating circumstances should be enlarged on bail." The Supreme Court has observed that lodging juveniles in adult prisons amount to deprivation of their personal liberty. Once a child is caught in the web of adult criminal justice system, it is difficult for the child to get out of it unscathed, the bench comprising Justices Dinesh Maheshwari and J.B. Pardiwala observed, while considering a writ petition filed by a murder accused undergoing life imprisonment seeking appropriate directions to the respondent state of Uttar Pradesh to verify the exact age of the convict on the date of commission of the offence. The Supreme Court has observed that the right to contest an election is not a fundamental right but only a right conferred by a statute. An individual cannot claim that he has a right to contest election and the said stipulation violates his fundamental right so as to file his nomination without any proposer as is required under the Act, the bench comprising Justices Hemant Gupta and Sudhanshu Dhulia observed, while dismissing a special leave petition filed by Vishwanath Pratap Singh. The court also imposed a cost of ₹1 lakh on Singh. The Supreme Court of India has held that the right to establish an educational institution is a fundamental right under Article 19, Clause 1, Subclause G of the Constitution, and reasonable restrictions on such a right can be imposed only by a law and not an executive instruction. The judgment was passed by a bench comprising Justices B.R. Gavai and P.S. Narasimha in petitions filed by the Pharmacy Council of India challenging the orders of various high courts such as Delhi, Chhattisgarh, Karnataka, whereby moratorium issued by the Pharmacy Council of India on opening new colleges for 5 years was set aside. In a significant development, the Supreme Court has sought the central government's response in an appeal filed against the split verdict of the Delhi High Court in the marital rape case on the validity of Exception 2 to Section 375 of the Indian Penal Code. A bench comprising Justices Ajay Rastogi and B.V. Nagaratna issued notice in the plea challenging Exception 2 to Section 375, which essentially provides that charges of rape cannot be attracted against a man who has non-consensual sex with his wife. The Supreme Court has suggested that the Union government could create a web portal containing the details of the foreign universities where the Ukraine returnee Indian medical students can complete their courses as per the Academic Mobility Program approved by the National Medical Commission. A bench comprising Justices Hemant Gupta and Sudhanshu Dhulia suggested that there should be a transparent system and that the web portal could give details of the fees and the number of seats in the alternate foreign universities which are compatible. Solicitor General of India Tushar Mehta said that he is not taking an adversarial stand and sought time to get instructions from the Union government regarding the suggestions of the bench. The Supreme Court has imposed 10 lakh costs on applicants for attempting to seek review of a judgment under the garb of miscellaneous applications. On perusing the applications, the bench of Justices B.R. Gavai and P.S. Narasimha observed that they are an attempt to seek review of the judgment and order under the garb of miscellaneous applications. Accordingly, the court imposed costs of ₹10 lakhs each on the applicants. The Supreme Court has continued to hear the batch of petitions challenging the Karnataka High Court's verdict, which upheld the ban on wearing of hijab by Muslim girl students in education institutions in the state of Karnataka. The matter is being heard by a bench comprising Justices Hemant Gupta and Sudhanshu Dhulia. Arguments were advanced by a host of counsels appearing on behalf of the petitioners. The next hearing is slated to take place on September 19th at 2 p.m. Advocate Shoaib Alam argued that the state cannot enter into a barter system with its citizens, asking them to surrender their right to privacy in exchange for the right to education. A criminal quashing petition has reached the Andhra Pradesh High Court requiring it to examine whether a transgender woman can file a complaint for dowry harassment under Section 498A of the IPC. The petition contends that a plain reading of Section 498A makes it clear that complaint with allegations under this section should be made by a woman, and hence a complaint under this provision by a transgender complainant is not sustainable in law. The petition seeks to quash a criminal complaint registered against the petitioner by a transgender woman claiming to be his wife. Taking cognizance of the matter, a single bench directed a stay of all proceedings in the pending criminal complaint on the file of the Additional Municipal Magistrate Court for 8 weeks. The Punjab and Haryana High Court has recently held that the effect of a magistrate's deposition in favour of a dying declaration can be eroded only when an efficacious cross-examination is conducted. The observation was made by a bench comprising Justice Sureshwar Thakur and Justice N.S. Shekhawat while dealing with an appeal against conviction for the offence of murder. The conviction was based on the victim's dying declaration. The Allahabad High Court has directed the CBI to probe a kidnapping case against 2 accused persons after they alleged that they were being implicated in false cases at the behest of 35 UP police personnel. The bench of Justice Suneet Kumar and Justice Syed Wais Mian ordered thus on a writ plea moved by the accused petitioners belonging to a Dalit family seeking a fair investigation into the allegedly fake kidnapping cases registered against them. It was a primary submission of the petitioners that the police officials of District Mathura were instrumental in lodging a large number of fraudulent and false cases either against the petitioners or his brother so as to pressurize them to compromise in earlier cases. Thank you. Keep watching Courts This Week on LiveLaw for more such updates. See you next week.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.